And with that, I'll ask my panelists to wave hello, and I will share some slides with you that provide a brief overview of the rule of law situation in Nigeria, and then I will hand it over to my panelists. So let me launch these slides. Okay. First, I want to say that this event is the outgrowth of a qualitative research program that I've been conducting for the past 6 months with support from the Knowledge Management Fund and the Knowledge Platform for Security and the Rule of Law. I was in West Africa earlier this year interviewing local programs to create narrative reporting about effective rule of law solutions. And this is an outgrowth of that. So these two programs that we're looking at today are very much exemplary of the kind of innovative solutions that we're interested in for the Access to Justice in the Sahel program. And I will share with you at the end of the presentation how you can find out more about that. So to give you an overview of the rule of law in Nigeria, I'd like to share some information from the World Justice Project, a nonpartisan research and programming organization based in Washington, D.C. that promotes advancement of the rule of law worldwide. The World Justice Project publishes the Rule of Law Index, which is a comprehensive overview of the rule of law in 128 countries and jurisdictions. That number continues to grow. We conduct 130,000 household interviews, survey 4,000 experts, and have over 500 variables to represent the rule of law. We look at 9 factors of the rule of law in the index, including constraints on government powers, absence of corruption, open government, fundamental rights, order and security, regulatory enforcement, civil justice, criminal justice. And today we're going to look at criminal justice in particular. We also measure informal justice, though that does not currently appear in the index score, so you'll see. To derive these scores, we have 2 primary forms of direct measurement of primary data. We have a general population poll in each country, which is a random survey of approximately 1,000 everyday citizens. We also conduct a qualified respondents questionnaire, which is a smaller sample, but it's a network survey, so we're reaching out specifically to people who are expert in 4 areas of the rule of law. And we validate that information using third-party sources. All of that goes into constructing our factor scores using a variable map. So you can see in this slide an example of the variables for constraint on government's power. That's factor 1. You can see how it's derived from subfactor 1.1, 1.2, and those are in turn mapped onto particular questions. So in Nigeria, we see several important rule of law challenges that are relevant to today's discussion. Overall, Nigeria performs below its regional and income groups for the rule of law. You can see here that it is ranked 23rd of 31 nations in sub-Saharan Africa with an overall score of 0.43 out of 1. And that places it 108 out of 128 countries worldwide for rule of law. So we can see this is a major issue in Nigeria, as for many countries in its neighborhood, including Mali, and then of course Cameroon, which ranks near the very bottom of our list globally. In the Rule of Law Index, we map our rule of law factors in a holistic way. So you see on this chart here that some of the kind of core rule of law concerns include absence of corruption, open government, fundamental rights, order and security, and regulatory enforcement. And I'd like us to look at 3 factors in particular today. So we have absence of corruption, order and security, and criminal justice. And what you're seeing here is a comparison of Nigeria to both its regional average and country average, and you can see it underperforms both of those averages on these three factors. If we get a little bit more into the weeds, you'll see within criminal justice, timely and effective adjudication is a key issue, as is corruption and due process of law. Under the order and security factor, we see the absence of crime and absence of civil conflict in particular are a huge issue in Nigeria. And if we break down corruption, we can see that in the executive branch, the police and the military, and in the legislature, corruption is a major issue. And I would also just add, it's not on this list, but timely and effective civil justice is also a large issue in our rule of law findings from Nigeria. So why do we want to focus on pretrial detention when we're strengthening criminal justice in Nigeria? There are 4 sub-factors of our criminal justice score where Nigeria underperforms. There's criminal adjudication of the system is timely and effective. The correctional system is effective in reducing criminal behavior. The criminal system is free of corruption, and due process of the law and rights of the accused are observed. Now, I would suggest that all 4 of these factors are related to pretrial detention, and I hope that we can get more into those relationships during our breakout sessions today. Okay, with that, I will turn over the discussion to our case studies, and we'll hear first from Funmi Ayeni of the Lagos Public Interest Law Partnership. So, Ms. Ayeni, if you want to unmute yourself.
Hello, can you hear me?
Yes, we can hear you.
Okay, hi everyone. So good day to you all joining us from different parts of the world. As Joe already mentioned, my name is Funmi Ayeni, and I'm the Chief Executive of the Lagos Public Interest Law Partnership, which is PILP for short. So I just wanted to quickly start off by thanking the organizers of the Knowledge Platform Security Rule of Law Conference for extending this invitation to me to discuss the work we do to expand access to justice in Nigeria, as well as our exciting collaboration with Aardschap Foundation, who are here today. The PILP was envisioned by the Lagos State government in 2012 as a public-private partnership aimed at expanding access to justice and providing comprehensive pro bono legal services where legal aid is limited to indigent and marginalized residents in the country. The idea came about as a result of the various inadequacies within the existing Nigerian legal aid scheme, which is beset by inconsistent access criteria, a restrictive means test, and limitations on the types of cases that are also eligible for legal aid. So we've since been registered as an NGO with a structure that reflects the several critical stakeholders that we believe should be involved in promoting access to justice. So they include several government ministries, departments, and agencies, such as the Ministry of Justice, the Nigerian Correctional Service, Nigerian Police Force, the Judiciary, NGOs, the Nigerian Bar, and many more. So we have about 12 partners in all. And we believe that this all-encompassing partnership with the relevant stakeholders is integral to us successfully enhancing access to justice for all in the country. We're currently operational in 8 states in Nigeria. So even though a number of government-funded legal agencies exist, as I mentioned, both at the national and state levels, the research shows that there's still a huge demand that needs to be met in terms of access to justice. PILP's own needs assessment studies underscore the strain on the Nigerian legal system. So we found that there's only one government council, one government paid council that's available for more than 50,000 Lagosian residents who are in need of legal aid, and nearly 40,000 Nigerians languishing in prison awaiting trial, which is what you refer to as pretrial detainees. So we call them awaiting trial inmates. And the data from our own Lagos Criminal Information System is quite appalling as well. It's a database from the Lagos State Ministry of Justice, which attempts to capture all the inmates in the federal custodial centers in Lagos, while also tracking the status of awaiting trial detainees. The most recent report highlights that a shocking 86%, that's 86% of the inmates in the correctional centers are awaiting trial. So that means they have not been convicted, they're in custody for many years awaiting trial. So we therefore run a clearinghouse where we match some of the unrepresented inmates with pro bono counsel. And we also run several programs aimed at further amplifying access to justice in the country. And one of our ongoing projects is the exciting collaboration that we have with Aardschap Foundation, which I look forward to discussing in more detail during the breakout sessions. Thank you all very much. Thank you, Joe. Sorry, Joe, I think you're still muted.
Thank you very much, Funmi. That was a great introduction overview to your work. That number 86% is really striking. So this is a really important discussion. Next, we have Joost van Onna and Melle Smets from the Aardschap Foundation.
Good morning, everybody. My name is Joost van Onna. I'm here with Melle Smets, who will introduce himself shortly. We want to talk to you today about the project, the Informal Justice Court, Funmi already mentioned. We are part of a research organization called Aardschap Foundation, where artists and researchers work together to investigate social problems and to find innovative solutions. So I do that from a research point of view, using research methodology. And my partner and founder of Aardschap Foundation does that from the art perspective.
Yes, thank you, Joost. Yeah, well, so to give a short idea of what we do is that we always seek for, well, you could say wicked problems or very complex issues. And pretrial detention obviously is something nobody wants, but it is really happening. So that you could, yeah, consider as a very complex problem, and at the same time it's there. So for us that was a challenging subject to work on. So Aardschap Foundation exists now for about 6 years. So we did a lot of research before this, and we always seek also for complex problems, also more for the informal forces in society. That's a great inspiration and also force to work from. So that also is now in the title of this project, the Informal Justice Court, where we also try to see how you can extend or use also the informal networks which are already in place to improve the situation in pretrial detention. But maybe that comes later, right?
Yeah, we'll go out more in detail in the breakout session. This is a project, the Informal Justice Court in Ikoyi Prison, which is the most congested prison in Lagos, where up to 90% of the inmates are awaiting trial. This is an innovative project that is supported by the KMF fund. What we are carrying out with the local partners like Mrs. Ayeni's organization. And in short, the project is a training program for awaiting trial inmates in the prison, aimed at improving the judiciary process through mock trials and pro bono assistance. The inmates will receive help of pro bono lawyers, and they will prepare their cases in mock trials inside Ikoyi prison. So they are well prepared for their actual case, and we also try to find innovative solutions in their case that can be presented to the court judge. But importantly, another goal of this project is also to raise awareness of the awaiting trial problems that exist in Lagos penal system. And one way we want to do that is we're going to make a theater play out of the stories that we gather through the informal court process. And this theater play will be performed by the inmates and will be performed in Ikoyi prison, and will be invite the important stakeholders in Nigeria to discuss possible solutions. So this is in short our project, and in the breakout session we're going to go in more detail. and we want to gather input from you on our project, which is ongoing, and also discuss how we can continue and scale the project afterwards. Thank you.
Mute.
Thank you very much, Joost and Melle. And finally, but certainly not least, we have Odi Lagi, who is a good friend of the World Justice Project and has been involved in my research now for some time in Nigeria. And she will be sharing a bit more about the clinical legal education services offered by the network of legal aid institutions in Abuja. So Odi, my pleasure to welcome you. Thank you very much.
Hi, everybody. Welcome to our session. It's nice to meet you all. And thank you, Joe, for the introduction. I'm Odi Lagi, and I work with NULAI, Nigeria, Network of University Legal Aid Institutions. And Funmi has really quite captured some of the problem that we have on pretrial detention in Nigeria, and which was one of the reasons that NULAI entered into working with law clinics on pretrial detention. So NULAI, we're based in Abuja, but it's really a network of university-based clinical legal education programs where our university law faculties teach law and have students work at law clinic and provide access to justice services. So we pool a human resource of at least about 3,000 law students annually that can provide legal aid services, paralegal services to support the gap that Funmi quite mentioned with providing legal aid in Nigeria. So working with law clinics, they provide, because in Nigeria, our law students can't present a case in court, but they do provide some huge services like interviewing detainees in prisons, doing drafting, the legal work that needs to support the work of pro bono lawyers so that it's easy to recruit more pro bono lawyers. And we've not had a culture of pro bono lawyers in Nigeria, and something also our program objective aims at building public interest lawyers. So law clinics do provide, students do provide the services, advocacy services with the different justice sectors to make sure that pretrial detainees are provided access to justice. So we've been working for over say since 2008 on pretrial detention. That's what we've been doing since, and sorry. So part of our work then involved, part of our work is, I put myself on timer. Part of our work involved working with the Nigerian prison, and during the work we saw that data gaps, and as Joe mentioned, timely effective adjudication was a key problem. So our law, a new law was passed, Administration of Criminal Justice, that tried to innovatively address this gap. So we now knew there was a reason to have data system that can track and monitor the implementation of that. So part of our work evolved with what students were doing in our prisons to supporting the Nigerian government develop case information management system to be able to take in the details of what is happening with detainees, their processing in court, and tracking them. So details of how this is being done, how it's aiding a timely adjudication of matter and access to justice we'll be dealing with as we enter the breakout sessions. Thank you all.
Thank you so much to all four of you. And I look forward to learning so much more during the breakout sessions. So we have just about 5 minutes for questions and answers. But before I ask you to submit your questions for the panelists in the chat function, I actually am going to ask a question to the audience. So in a moment, I'm going to launch a poll that will ask you what your primary motivation is for attending this session. And we just have laid out some of our goals, but if you could briefly, I'll launch the poll now. You should see it on your screen. Let us know, are you interested in understanding pretrial detention in Nigeria, hearing stories about effective interventions, exploring methods for legal education and action research, learning how survey data supports effective program design, helping to build capacity for successful prototypes? So if you just let us know now which of those goals is sort of your primary motivation, that will help us shape the way that we proceed during the breakout sessions. And once you've submitted your response to that live poll, I'd ask you, please submit a question in the chat function for our panelists. Okay, so it looks like most of our audience are interested in learning more about the effective stories of interventions, or stories of effective interventions, excuse me. And we also have some interest in program design, building capacity, and understanding the issue in general. So that I think will really be useful for us as we explore our breakout sessions. Sorry, I'm having a little difficulty seeing the chat function.
Do you want me to read
Here
it
we
for
go.
you?
Okay. So we have some questions coming in the chat function. Thank you. So we have a question first from Lisa Denny. If you'd like, Lisa, if you'd like to unmute yourself and ask your question, you can do that, or I can ask it for you.
Sorry, I'm similarly having problems navigating Zoom. It's late in the night where I am. Thanks very much. I was just interested to hear a little bit about these informal courts and their relationship between, or their relationship with the formal court system, and whether you have people from the formal courts who participate in the informal courts, or how that interface works. And then in addition, just the outcomes that you're seeing. So, are you finding that the people who use the informal courts go on to have a better outcome in the formal court system, or are you not that far necessarily in the intervention yet? Thanks.
Hi, thank you for that question. Very good question indeed. Thanks. Funmi, do you want to respond, or should we take a start?
I think you should go ahead, but if you need me to chip in, I'll be happy to.
Yeah. So regarding your last part, well, we're still not that far. We're in the middle of the project, and the informal court session itself will start in January. So we cannot really see the effectiveness of our approach yet. But one of the ways that we want to assure that it may become effective is to think about ways how the informal court connects to the formal system. And one of the ways we are thinking about is to select cases that can be brought into the restorative justice courts that have begun in Lagos State, if I'm not mistaken, since last year. One of our angles in this project is to think about alternative restorative sanctions where possible, and to bring this to the attention of the court judge to see there, or the prosecutor to see whether there's a possibility to transfer the case to a restorative justice court. And in this way, we want to connect it to the formal system. Maybe Funmi, you want to add?
Yeah, so I think Joost has pretty much covered the question. So the Lagos State government has introduced the Restorative Justice Center, which is a diversionary program that is victim-centered. And we hope like we could send minor offenses to that center. So the idea is that this program would hopefully be able to supplement what the government is currently doing. And I don't know if you already mentioned, but we also plan to include certain actors from the real court system, so such as a real prosecutor from the Ministry of Justice, Department of Public Prosecutions. And we also want to include a real judge to also participate in the project. So, and then of course, we're going to have real pro bono lawyers from our organization also participating. So all this with the idea that they could then help to more easily transfer this program into the real court setting and, you know, help implement it better into a formal setting. So I hope that covers your question.
Great, thank you both. I think we have just one more minute for another question from Claire Brown, who wants to know about political will. So the question is, you know, have there been challenges in terms of getting the necessary political will to overcome the pretrial detention issue? And perhaps Odie, would you like to speak to that issue briefly before we jump into the breakout sessions?
Okay, so thank you. I wouldn't say directly that political will is the current problem. It might have been in the past to building up, but where we are right now, there is so much reform that's gone in. So there has been a great and tremendous improvement in political will with the passage of the laws and will setting up of criminal data system across the different sectors. So a couple of reforms that show strong political will is coming on, but there are still challenges of capacity and infrastructure. So there are a couple of things that fit into the box that you have to address from all angles. But political will, we have come up from where we used to be. It contributed, but it's not the major problem now. I also see somebody ask something about the legal assistance. Why is it because there are so many arrests? We usually say in Nigeria, the population of people you have in detention, equivalent to the population of Nigeria, is really small. So it's not really about the number of people being arrested, but the overuse of pretrial detention for whoever is arrested. So in that situation, even if it's 10 people, like 80% of those 10 people are waiting trial for a long period is an issue. But in a population of 200 million, where you have just about 60,000 in your prisons, that's not a high number of arrests. It's just that the system is not delivering justice at the time when it's supposed to deliver justice.
Great, thank you. And then we do have another question, but I think that Odie, you began to address that question somewhat, but I'll share it just before we jump into the breakout session. So if it's something that comes up during those breakout sessions, I think that would be of interest as well. So forgive me for if I don't pronounce the name correctly, but Martine, I believe, asks whether legal education and legal assistance address the main causes of high levels of pretrial detention, or are there concerns about why so many people are arrested in the first place, right? I think that we're beginning to address that. I think the question of arrests, though, if it does come up in the breakout sessions, could be interesting as well. Okay, so with that, I think we'll jump into the most interesting, for me at least, aspect of this, which is to hear a little bit more from the audience, to have a little bit more depth from each of the programs that we're looking at today. So we will launch the breakout sessions. And we'll be in those for about 20 minutes and then come back and wrap up and find ways to connect with each other moving forward. So please join the breakout room as soon as that pop-up comes in your window.
Hi, Paul. We're in breakout sessions. If you'd like to join, you can. You should have gotten a notification. If you'd like to join the breakout session, you can click to join. Yeah, perfect. Did you get the request? I can't hear you. You're on mute. Sorry. I still can't hear you. Nope, can't hear you. Sorry. You should be able to join the breakout session if you'd like to. Hi, are you able to join? I'm really sorry. I still can't hear you. I still can't hear you. Sorry. Maybe if you press the unmute button, it should be in the bottom of your screen on the left-hand side. Yeah, perfect. There you go. Yeah, actually, no, maybe the earphones, maybe if you take out the earphones. Yeah, maybe, hello?
Hello?
There you go, there you go. Perfect.
Yeah, I can't hear you much, but I'll try as much as possible to be able to hear you. I'm unable to get the thing done.
You can't join the breakout session?
Yes, I tried. Let me try it once more.
Okay, all right. Let me know if you need help.
Let me try it.
Okay,
Okay.
yeah.
Hi, everyone. Welcome back to our main session. I was just in the middle of saying how important I found the program that NULAI is participating in around the Administration of Criminal Justice Act in Abuja, how important it is to have a broad range of civil society stakeholders participating in that process. And to be telling stories about these kind of effective solutions. So I hope that your breakout sessions were equally productive. I know that it's not a lot of time to get into such thorny issues, and there will be an opportunity at the end of the presentation to give us a little bit of feedback, as well as to sign up for future events that the World Justice Project and Aardschap may be conducting on this topic. So the conversation does not have to end today, and we're super grateful for your time and participation. At this point in the presentation, we are going to just share a few key takeaways, a few key insights. We also, I think, welcome if you have a comment that you'd like to make in the chat. Your reaction to the session, we're really keen to hear that. I have some questions that we could look at as well, but let's just turn it over, I think, to Aardschap and to the PILP and say, you know, what are some of the key insights that you took away from your session on action research and the informal justice system, informal court project?
Yeah, we really struggled to manage time. To be quite honest, we had very little time because of our limited experience in time management on Zoom in leaving room for good questions. So maybe Funmi, you want to add some of your insights?
So I think we did manage to get like literally a couple, so 2 questions in, and I think it was just bordering on trying to understand if Nigeria has community service, or if the only alternatives to serving time in the correctional centers is fines, because I had mentioned that some of the inmates that we help to secure their release, it's just a matter of paying fines as little as $20 to $40. And so some of them have spent many years in prison because they can't afford fines as little as that. And so I explained that, yes, we do have community centers for, you know, alternative sanctions. It's just that they're severely underused. And so there's a push for those to be used, you know, more effectively, and training the magistrate courts to divert such minor offenses to such centers rather than, you know, sending them to the correctional centers. So those are a few, you know, of the brief discussions we had. And then we obviously took everyone through what the project is going to be about. Thank you.
Great. And Odi, did you have any takeaways? Did you have any takeaways from our session? I would love to hear you speak to the big picture now that we're coming to the end of our time. In particular, the question of political will came up again, and I'm curious, you know, how this issue of pretrial detention fits into the larger concern about security and the rule of law in Nigeria, and whether that has a role to play in creating political will. So are people in Nigeria, are people really thinking about the prisons as one piece in this larger struggle to, for example, constrain extremism, improve security, create more legitimacy in government? How are you thinking about the big picture political will question at the end of the session?
So if I may add, the prison acts, just a new prison act that have just been passed that gives the prisons the right to actually reject detainees if they are overcrowded. And some of that is that this new law, with the addition to the Administration of Criminal Justice Law, and with the addition to their information management system, might help in giving the prison the adequate data they need to do that. Now, if that is, if we can achieve that, and that's not wearing like the system's hat, and I do believe we can achieve that, because when we started the information management system, it looked like we couldn't achieve it. If we can achieve that, I think it will give the population more trust in the rule of law. And also, because currently there's some of the issues we are facing right now. There is current police protest going on how police is harassing people on the way. And the police's main instrument has always been, if you are arrested and they can charge you with armed robbery or something and put you in the prison awaiting trial and not say until further investigation, and then you'll be forgotten. So if the prisons are able to exercise this power and be able to deliver this, and if civil society also hold them accountable to doing that, I think the population will begin to have more trust in our rule of law. This will reduce extrajudicial killing both by the security and by citizens, because citizens do take law into their hands to, like, if you steal my stuff, I'm going to deal with you the best way I think. So I think it will improve rule of law. And once our trust in our system improves, it will address some of the security issues that we are looking at. Of course, there are other issues that contribute to insecurity, economic issues and others. But if we can address what we're doing right now, and the new laws and the new reforms that are on ground, can actually boost improving rule of law in Nigeria.
Great, thank you so much. I think that's a really terrific point. And I guess my final takeaway here around this topic would be just to emphasize the importance of creating one program or one system within this very complicated network of moving pieces that functions well, and generating political will by building on that success and bringing that success to other government stakeholders or other civil society organizations, bringing that data and just kind of making the progress that is happening. At the World Justice Project, we say that in any country, no matter what the state of the rule of law is, there are always islands of integrity. There are always people within government, people in civil society who are working to move the needle forward on the rule of law. And so I want to thank our panelists, not just for their participation today, but for really playing that role in Nigeria. So thank you all so much. In the last 2 minutes, I just want to share a couple of ways that you can continue to be involved in the conversation. The first is we have a small, very short, 1 to 2 minute feedback form that you can access by going to the link on the screen, bit.ly/KPSRL2020. At the World Justice Project, we are also involved in data collection and analysis. So you can visit our Rule of Law Solutions portal. We also have interactive data portals for the Rule of Law Index and new data product of Global Insights on Access to Justice, which looks specifically at justice journeys taken in each country. And very exciting to announce just this week, we also have the World Justice Challenge 2021, which is a major cash award prize. We'll be giving out to 6 different effective programs, policies, effective solutions around the world that are working to improve rule of law in the wake of COVID-19, in the wake of the pandemic. We'll be focusing on access to justice for all, accountable governance, fundamental rights and non-discrimination, and anti-corruption in open government. So you can learn more about that, submit solutions, tell your friends, tell people who are working on these issues about this program, and they may receive recognition, they may receive financial reward in response to their good work. And the deadline for that is December 11th, 2020, and we will be sharing those solutions on a variety of platforms as well. So with that, I want to thank everyone for their participation today. a huge thanks to KPSRL, Klingendale, and KMF for making this event possible, and to our partners behind the scenes. Thank you, Christian, for joining us today. It's great to see your face here. And thanks to all of you for your participation. I really look forward to joining some of the other sessions today and hearing from some of you about the great work that you were doing in this area. And finally, please don't hesitate to reach out to me if you have any feedback, comments, questions, if you'd like to share solutions pertaining to access to justice in West Africa or Nigeria or in the Sahel. I'm also working now on anti-corruption reform in Southeast Asia. So if you have comments about that, I know a lot of people in this group are expert in multiple areas. So yeah, so I'm super open to hearing from people who are participating today. And thank you again to our panelists. You were awesome. We did a lot in very limited time. And I look forward to catching up with all of you again at an event in the future.
Thank you.
Thanks, everyone. Enjoy the rest of the conference.
Bye, everyone. Bye.